Let's look at the New Haven firefighters case, the Ricci case. In that case, the city of New Haven told firefighters that they would take an exam, set forth the process for it, that would determine who would be eligible for promotion. The city spent a good deal of time and money on the exam to make it a fair test of a person's ability to serve as a supervisory fireman, which in fact has the awesome responsibility at times to send their firemen into a dangerous building that's on fire. And they had a panel that did oral exams, wasn't all written, consisting of one Hispanic and one African American and one white. And according to the Supreme Court, this is what the Supreme Court held. The New Haven officials were careful to ensure broad racial participation in the design of the test and its administration. The process was open and fair. There was no genuine dispute that the examinations were job-related and consistent with business purposes, business necessity. But after the city saw the results of the exam, it threw out those results because, quote, not enough of one group did well enough on the test. The Supreme Court then found that the city, and I quote, rejected the test results solely because the higher scoring candidates were white. After the tests were completed, the raw racial results became the predominant rationale for the city's refusal to certify the results, close quote. So you've stated that your background affects the facts you choose to see. Was the fact that the New Haven firefighters had been subject to discrimination one of the facts you chose not to see in this case?
No, sir. The panel was composed of me and two other judges in a very similar case, the Seventh Circuit, in an opinion authored by Judge Easterbrook. I'm sorry, I misspoke. It wasn't Judge Easterbrook. It was Judge Posner. Saw the case in an identical way. And in neither judge, I've confused some statements that Senator Leahy made with this case, and I apologize. In a very similar case, the Sixth Circuit approached a very similar issue in the same way. So a variety of different judges on the appellate court were looking at the case in light of established Supreme Court and Second Circuit precedent and determined that the city, facing potential liability under Title VII, could choose not to certify the test if it believed an equally good test could be made with a different impact on affected groups. The Supreme Court, as it is its prerogative in looking at a challenge, established a new consideration or a different standard for the city to apply, and that is, was there substantial evidence that they would be held liable on the law? That was a new consideration. Our panel didn't look at that issue that way because it wasn't argued to us in the case before us, and because the case before us was based on existing precedent. So it's a different test.
Judge, there was a apparently unease with